I, Engineer Eric Ogola, an engineer, a self-taught lawyer, a jurist, an arbiter, and MP Kisumu Central 2027. And I want to put Speaker Moses Wetangula for having violated and contravened our constitution and constitutionalism. And I want to tell you that when this Constitution of Kenya 2010 was promulgated, I was the first person to get a copy of the proposed constitution in 2010 before it was voted in that plebiscite. And I purely understand what this constitution says and its interpretation. Though the interpretation of this constitution is clearly left to the High Court of Kenya that is established under Article 165 of the Constitution. That gives the High Court unlimited, original, and exclusive jurisdiction to make determination on matters pertaining to the interpretation of this constitution, and also on matters to determine whether a particular section or particular article of this constitution has been violated or contravened. And also under Article 22, any person has the right to institute a court proceeding claiming that particular rights in the Bill of Rights or fundamental freedom has been violated. So when that petition was taken to the High Court, which has been given that jurisdiction by our own constitution to make a determination and a ruling pertaining to that petition, you cannot purport to overturn a court order. It is rightful for you because it will be the highest order of impunity. Because we are not a dictatorial democracy, we are not a tyrannical regime where strong men come from nowhere and purport to overturn a court order. Until that particular ruling has been appealed, you cannot overturn a court order. So, Moses Wetangula, allow Junet Mohammed to be the majority leader, while Millie Odhiambo to be the majority chief whip, and also to allow Gladys Bosh-Sholei to be the Speaker of the National Assembly, because you have not been partial in terms of interpretation on issues concerning Parliament. Because any decision that has been brought before you, you have made partial decision, but you should act with impartiality in determining matters which has been brought before you. So, Wetangula, if you can read clearly Article 22, the High Court has that jurisdiction. And under that jurisdiction, the court has been given the limit under which it can operate. It can either offer a judicial injunction, it can declare that particular right, and also it has the jurisdiction to give the benefits or offer invalidity of a particular section of the Constitution or particular legislation which has been declared unconstitutional. So, Speaker Moses Wetangula, we are in a constitutional democracy. We are practicing our constitutionalism, and you are going to set a very, very dangerous precedence in our jurisdiction to overturn a court order. And referring or inferring to different jurisprudence in different jurisdictions, there is nowhere where Parliament has ever, or the Speaker of National Assembly has ever overturned a court order. So allow Junet Mohammed. Junet Mohammed has the capacity, the capability, the knowledge, the potential, and all characterization I can use to describe his potential to be the majority leader. So with that, Moses Wetangula, please respect the court order and let us practice our constitutionalism.